On July 18, 2014, Florida State University law professor Dan Markel pulled into the garage of his Tallahassee home. He had just left the gym. Earlier that morning, he had dropped his 2 young sons off at daycare. It should have been an ordinary Friday. Instead, someone had followed him home. At 11:02 that morning, Tallahassee police received a report of a shooting. Officers found Dan inside his car with gunshot wounds to the head. There was no sign of a robbery, no obvious suspect, and no clear reason anyone would want him dead. But a neighbor had seen something. A small, light-colored car backing out of Dan's driveway. It looked like a Toyota Prius. That single detail would lead investigators nearly 500 miles away to 2 men Dan had apparently never met, and to the prosecution's claim that his murder began with a bitter family dispute. This is the murder of Dan Markel and the case against Sigfredo Garcia. Hi everyone, I'm Ashley and welcome back to GORI Explorations. If you're new here, I use trial testimony, police reports, court filings, and other official records to tell these stories through the evidence presented in court. In this case, it is especially important to separate what investigators found, what witnesses testified to, and what prosecutors argued. Sigfredo Garcia pleaded not guilty. The state would have to prove its case beyond a reasonable doubt. But before there was a trial, there was a quiet Tallahassee neighborhood, a murdered father, and one unusual car. Dan Markel was 41 years old. He was a professor at Florida State University College of Law, a legal scholar, and the father of 2 young boys. On the morning of July 18, 2014, Dan dropped his sons off at daycare at approximately 8:50. From there, he drove to Premier Health and Fitness Center. Dan arrived shortly after 9 o'clock. Surveillance video later showed something else arriving around the same time, a light green or silver Toyota Prius. While Dan was inside, the Prius changed parking spaces. When he left the gym at approximately 10:38, the Prius left behind him. Dan drove home to Trescott Drive. The Prius followed. Shortly after Dan pulled into his garage, he was shot twice. At the time, Dan was speaking to someone on his cell phone. According to the probable cause affidavit, the person heard Dan say that someone he did not recognize was in his driveway. The call then became muffled. Dan stopped responding. Neighbors heard the gunfire. One looked outside and saw a small, light-colored car backing away from Dan's home. Police and paramedics arrived within minutes. Dan was transported to the hospital, but his injuries were devastating. He died the following day. Investigators found no indication that the shooting was part of a burglary or robbery. Everything about the scene suggested Dan had been deliberately targeted, but that only deepened the mystery. Dan was not known to live a dangerous life. No one had taken his wallet or tried to enter his home. Why would someone follow a law professor from his gym and shoot him in his own garage? As I was reading through the testimony, one thing really stood out to me. Investigators didn't walk into this case knowing they were dealing with a murder for hire. They're simply trying to answer the same questions any detective would ask after a homicide. Who was the victim? Who had a motive? And who was seen near the scene? Everything else came later, one piece at a time. The first real lead did not come from a confession or a fingerprint. It came from the Prius. In 2014, doorbell cameras were not yet watching nearly every residential street. To find the Prius, detectives had to search for other cameras along the route. City buses, businesses, a bank, a government facility. Each camera captured only a fragment. Together, those fragments showed a similar Prius following Dan's vehicle before the shooting and leaving the area afterward. The car had several distinctive features: tinted windows, a SunPass transponder, a missing tow hook cover on the front bumper, and a dark passenger side mirror casing. Investigators believed it was a 2006 to 2009 Prius in a color Toyota called Silver Pine Mica, a pale green that could look silver on camera. This is one of my favorite parts of the investigation because it's real police work. There's no dramatic confession or surprise witness. It's detectives interviewing neighbors, reviewing surveillance footage, and chasing down every small lead. At this point, they still don't know. They're investigating what prosecutors would later describe as a murder for hire. They're simply following the evidence wherever it leads. The Sun Pass became critical. Investigators compared toll activity with cell phone records and narrowed the search to a rental car company in North Miami. The company had rented a green 2008 Toyota Prius from July 15th through July 21st, 2014. The name on the contract was Luis Rivera. A second phone number was written on the agreement beside the word brother. Investigators linked that number to Sigfredo Garcia. Now detectives had two names. They also had evidence suggesting the men had traveled from South Florida to Tallahassee together. Cell phone records placed their phones moving north on July 16th. A motel receipt and phone data placed them in Tallahassee. On July 17th, both phones appeared in the area of Dan's home. On the morning of the murder, cell phone records placed both phones within the general area that included Dan's gym. Then Garcia's phone went quiet. Its last activity before the shooting occurred shortly before 10 a.m. It did not become active again until afternoon, when records placed it near Lake City, already heading away from Tallahassee. At 12:30, Garcia called Catherine McBanois. Later that evening, a bank camera captured the rented Prius at an ATM during the return trip south. Rivera could be seen driving. Investigators identified Garcia in the front passenger seat. The Prius showed the same unusual features seen on the Tallahassee surveillance footage. I think this is where the case really hooked me. Finding the Prius was a huge step, but it didn't solve the murder. Instead, it created an even bigger mystery. Investigators finally had people to investigate, but they still didn't know why these men would have any connection to Dan Markel. At this point, the investigation was opening up, not closing. Investigators searched for a connection between Dan and the two men. They found none. Dan did not appear to know Rivera. He did not appear to know Garcia. The men lived hundreds of miles away, and investigators found no legitimate reason for them to be in Tallahassee when Dan was killed. If they had not come because of something personal between them and Dan, the next question was unavoidable. Who had brought them into his life? The prosecution's theory of motive began with Dan's divorce from Wendi Adelson. Wendi was also a law professor at Florida State. She and Dan shared two young sons. When Wendi filed for divorce in September of 2012, she moved with the children to her parents' home in South Florida. Dan objected, and she returned with the boys while the relocation issue went before the court. In June 2013, a judge denied Wendi's request to relocate with the children. That decision mattered because it kept the boys in Tallahassee, nearly 500 miles from Wendi's family in South Florida. The divorce was finalized that following month, but the conflict did not end. Court filings showed continued disputes over money, parenting, and the children's relationship with their grandmother, Donna Adelson. In March 2014, Dan asked the court to restrict Donna's unsupervised time with the boys. He alleged that she had made disparaging remarks about him to the children. A hearing had not yet taken place when Dan was murdered. According to the probable cause affidavit, investigators believe the motive grew from the Adelson family's desire for Wendi and the boys to move south, together with the pending court dispute that could affect Donna's access to her grandchildren. That was the state's theory. It was not proof by itself. This is an important point in the trial because motive isn't the same thing as proof. Even if jurors believed there was conflict over the divorce and the children, that alone didn't prove anyone committed a crime. The prosecution still had to connect the people they accused to the evidence they had spent weeks presenting. The connection prosecutors presented ran through Catherine McBanois. McBanois had been in a relationship with Wendi's brother, Charlie Adelson. She was also the mother of Sigfredo Garcia's two children. To prosecutors, that relationship placed her between the family they argued had the motive and the man they accused of carrying out the shooting. Dan Markel knew Wendi Adelson. Charlie Adelson knew Catherine McBanois. Catherine McBanois knew Sigfredo Garcia. Garcia knew Luis Rivera. The state argued that this was the chain that connected a custody fight in Tallahassee to two men from South Florida. The defense disputed the state's interpretation. Knowing someone was not a crime, and family conflict was not evidence that Garcia committed murder. Prosecutors still had to explain what Garcia and Rivera had done in Tallahassee. For that, they called a man who admitted he had been part of it. Years after Dan's murder, Sigfredo Garcia went on trial. The state presented crime scene evidence, surveillance footage, rental records, motel records, toll data, and cell phone records. Then prosecutors called Luis Rivera. Rivera was not an innocent witness who happened to see the crime. Rivera had pleaded guilty to second-degree murder and received a 19-year sentence as part of an agreement requiring him to cooperate and testify truthfully. The prosecution disclosed that agreement. The defense argued that the agreement gave Rivera a powerful incentive to shape his testimony in a way that benefited the state. Rivera's credibility would become one of the most important questions in the case. As I was reading through the trial transcripts, I noticed the prosecution didn't rush to put Luis Rivera on the stand. They spent time laying a foundation first. By the time Rivera testified, the jury had already been introduced to the crime scene, the investigation, and much of the physical evidence. That way, when Rivera began describing what happened, jurors already had context for what they were hearing. Rivera told the jury there had been 2 trips to Tallahassee. The murder did not happen on the first one. According to Rivera, Garcia asked him to drive north with him before July 18th. Rivera testified that they followed Dan during the first trip but lost track of him, and the plan was not carried out. They returned to South Florida. The defense later challenged part of Rivera's account with a traffic citation that appeared to indicate Rivera was alone when he was stopped during that trip. The thing that I noticed about the prosecutor's questioning is they didn't jump straight to the shooting. They took their time. They wanted the jury to understand that, according to Rivera, this wasn't a spur-of-the-moment decision. If the jury believed him, the first trip suggested planning. Then came the second trip. Phone data and records showed Garcia and Rivera leaving the Miami area on July 16th and reaching Tallahassee after midnight. Rivera testified that they watched the area around Dan's home and followed his movements. On July 18th, their surveillance trail placed the Prius at Dan's gym. When Dan drove away, the Prius followed him home. Rivera testified that Garcia got out of the car while Rivera remained behind the wheel. Then Rivera heard gunshots. Garcia returned to the Prius and they drove away. The 2 men began the long trip back to South Florida. This was one of the most important moments in the trial for me. Rivera wasn't just describing what prosecutors believed happened, he was admitting his own involvement. At the same time, I kept asking myself the same question the jurors had to answer. How much of his testimony can be trusted? That's why I think the prosecution spent so much time connecting his testimony to the physical evidence. Rivera's account gave the jury a story. The records would determine whether parts of that story could be independently checked. The state did not have a video of the shooting. The murder weapon was never recovered, and Rivera came to court with a criminal history and a plea agreement. So prosecutors focused on corroboration. If Rivera said they rented a Prius, there was a rental contract. If he said they drove from South Florida to Tallahassee, there were toll records and cell phone data tracking that movement. If he said they stayed in Tallahassee, there were motel records and a witness who identified both men. If he said they watched Dan before the murder, surveillance footage showed the Prius at the gym and following Dan's route. If he said they fled south afterward, toll records, phone data, and the ATM video traced the return trip. And if Rivera placed Garcia in the Prius, the ATM camera showed Garcia sitting beside him only hours after Dan was shot. Investigators didn't ask the jury to rely on just one piece of evidence. It was more like assembling a giant puzzle. A rental record by itself doesn't prove murder. A surveillance image by itself doesn't either. But when multiple pieces of evidence begin pointing in the same direction, the picture becomes much clearer. The phone records also showed communication surrounding the trip. Phone records showed frequent communication between Garcia and Magbenois before the murder. After going silent around the time of the shooting, Garcia's first outgoing call was to Magbenois as he traveled away from Tallahassee. The state argued that the timing and relationship supported its murder-for-hire theory. I noticed throughout this trial that prosecutors rarely asked the jurors to make a leap. Instead, they tried to connect one fact to another. They'd introduce a relationship, then a phone record, then testimony explaining that relationship. Whether you agreed with their conclusions or not, you can see they were trying to build the case step by step. But none of those records could show the jury what happened inside the Prius. Cell towers could place a phone in a general area, not put a gun in someone's hand. A rental agreement could prove that a car was rented, not why it was rented. Surveillance footage could show a Prius following Dan, but the images were not the same as a clear recording of the shooting. For the final step, the state still relied on Rivera, and the defense attacked him directly. On cross-examination, Garcia's attorneys reminded the jury exactly who Luis Rivera was. He admitted participating in the crime. He had made prior inconsistent statements, and his plea agreement spared him from facing the same potential consequences as Garcia. The defense argued Rivera had every reason to shift blame away from himself and toward the man seated at the defense table. They also challenged the state's interpretation of the records. Travel was not murder. Communication was not murder. Knowing Catherine McBenoit was not murder. The defense's position was that the evidence only became incriminating if the jury first accepted Rivera's version of events. Prosecutors answered that Rivera knew details because he had been there, and that the independent records matched too many parts of his accounts to dismiss him entirely. The jury did not have to decide whether Rivera was a good person. It had to decide whether he was telling the truth about Sigfredo Garcia. One thing I appreciated about the defense was that they kept bringing the focus back to the burden of proof. They weren't required to explain everything that happened. Their job was simply to convince the jury that the state hadn't proved its case beyond a reasonable doubt. That burden never shifted. Garcia did not have to prove where he had been or offer an alternative explanation for Dan's murder. The state had to prove beyond a reasonable doubt that he was responsible. By closing arguments, both sides were working with the same central evidence: the Prius, the phones, the trip to Tallahassee, the relationship between Garcia and McBenoit, and the testimony of Luis Rivera. Closing arguments are fascinating because there usually aren't any surprises. Instead, each side takes the same evidence you've been hearing about throughout the trial and tells you how they believe it should be interpreted. By this time, the jurors had everything they needed. The only question left was whether the prosecution had proven its case beyond a reasonable doubt. The prosecution asked jurors to look at the whole picture. It argued that Rivera's testimony was not standing alone because records created years before his testimony supported key parts of it. The defense asked jurors to look at the gaps. It argued that the state could not turn travel and phone records into proof of murder without trusting a cooperating accomplice. Then the case went to the jury. The jurors returned with a unanimous decision. On the charge of first-degree murder, they found Sigfredo Garcia guilty. They also found him guilty of conspiracy to commit murder. Garcia was sentenced to life in prison for first-degree murder, followed by a consecutive 30-year sentence for conspiracy. The jury found him not guilty of solicitation. For the state, the verdict meant the jury had accepted its case against the man prosecutors identified as the gunman. But the state had always argued that Garcia did not act alone. His conviction did not end the larger investigation into the alleged murder-for-hire conspiracy. I think it's easy to watch a guilty verdict and feel that the story is over. But in this case, it really wasn't. Garcia's conviction answered one important question: whether the jury found the state had proven beyond a reasonable doubt that he carried out the murder. It didn't answer every question about how this crime came together or who else might have been involved. Those answers would continue to unfold in the years that followed. In the years after Garcia's conviction, prosecutors secured convictions against others they alleged were involved in the murder-for-hire conspiracy. Wendi Adelson's brother, Charlie Adelson, was convicted in 2023. Their mother, Donna Adelson, was convicted in 2025. Both were found guilty of first-degree murder, conspiracy, and solicitation. Wendi Adelson has never been charged and has denied any involvement. Her father, Harvey Adelson, has also not been charged. And behind every name, phone call, court filing, and theory was the reason this case existed at all. Dan Markel had been murdered. He was a professor and scholar, but to his family, those titles were only part of who he was. He was a son, a brother, a friend, and the father of 2 young boys. His family and colleagues have worked to ensure that he is remembered for the life he lived, not only for the way it ended. Thank you for watching this episode of GORI Explorations. After reviewing the evidence presented at trial, what do you believe was the strongest part of the state's case against Sigfredo Garcia? Was it Rivera's testimony, the Prius, the cell phone records, or the way those pieces fit together? Let me know your thoughts in the comments. If you found this documentary informative, consider subscribing for more true crime stories told through trial testimony, court records, and official documents. Thank you for watching, and I'll see you in the next case.